Hello, this is Chrissy De La Paz and this is Rappler Talk. We'll be talking to Attorney Francis Lim of Accra Law, Legal Counsel of Rappler, on the SEC decision to revoke its incorporation papers for allegedly violating the Constitution. Good day, sir.
How are you?
Fine, sir.
Yeah.
Sir, first of all, can you describe what are Philippine depository receipts are, and what does it represent?
Well, a depository receipt is a financial instrument that gives the holder or the person to whom it is issued some economic benefits, without making that person a stockholder of the issuing corporation. In this particular case, for example, the issuing corporation is Rappler Holdings Corporation. So, and the PDR holder involved is Omidyar. Okay, Omidyar will be entitled to some economic benefits that will be given by Rappler Holdings without making Omidyar a stockholder and therefore no right to vote of Rappler Holdings Corporation. Okay, it's a global financing instrument that is used not only here in the Philippines, but also other parts of the world. For example, PLDT, Globe, Ayala have issued shares that are the underlying shares for the depository receipts issued by banks in the United States, for example. So it's not unique to the Philippines. Now, what is important to note is, unlike a share of stock, where the holder or owner of the share of stock is also a part owner of the corporation, okay, and has the right to vote in the corporation, a PDR holder is not an owner of the issuing corporation or of the corporation whose shares form the underlying assets of the PDR. And as such, the PDR holder, like Omidyar, does not have the right to vote in RH Holdings Corporation, okay, or in Rappler Inc. That should be very clear.
So just to clarify, these are different from shares of stock.
Very different from shares of stock. Because a share of stock gives the shareholder ownership rights in the company and gives the shareholder the right to vote in the company. That is not the case for a depository receipt. Now, why is it called a PDR, Philippine Depository Receipt? Because in this particular case, both the Rappler Holdings and Rappler Inc., whose shares of stock form the underlying assets for the depository receipts, are Philippine companies. In the United States, they call it ADR, American Depository Receipts. If it is issued globally, they call it GDR, Global Depository Receipts.
But sir, regarding the Omidyar PDRs, did the provision give Omidyar veto powers over affairs of Rappler Holdings or Rappler Inc.?
If you read the question provision, and if you read it carefully, the question provision merely says RH undertakes to cause Rappler Inc. not to amend its articles of incorporation without getting the approval of 2/3 of the PDR holders. So on its face, okay, it appears to be a veto power. Yeah. But legally, it is not.
How so, sir?
Why? Because it's just an undertaking of Rappler Holdings. I undertake to cause Rappler Inc. not to amend. Okay? But Rappler Inc. does not have any obligation to amend, to comply with that condition if it does not want to. So what happens if after requesting Rappler Inc. Not to amend its corporation, its articles of incorporation, Rappler Inc. does not follow the instructions?
But
Okay? So, then Rappler Inc. will proceed, and in fact can proceed to amend its articles of incorporation even without the consent of the PDR holders, of the PDR holder, in this particular case, Omidyar. Now, what's the right of Omidyar? Okay? So, sasabihin ng Omidyar, you, Rappler Holdings, violated your undertaking. Okay? So, it merely gives Omidyar a ground to terminate the relationship. In other words, to terminate the depository receipts. Parang ano it's like I think a PDR is more akin to a commercial paper, to a loan agreement. Okay? For example, ABS-CBN or GMA Holdings or even Rappler Inc. gets a loan from a foreigner, from a foreign bank. It's a standard provision in loan agreements that the borrower, in this case either ABS-CBN, ABS-CBN, GMA, or Rappler Inc., okay, will not do certain things without the consent of the lender. That's a very standard provision. So would that make, for example, the three borrower companies cede control to the foreign bank? No. It's just a negative covenant. Now, what if the Philippine lender proceeds, for example, to amend its articles of incorporation and bylaws without requiring the consent of, getting the consent of the foreign lending bank? So the foreign lending bank will just declare the borrowing Philippine corporation to be in breach of the obligation. Okay, and therefore may declare it may be an event of default. But that does not necessarily mean that by including that negative covenant, the foreign bank has control or becomes the owner of ABS-CBN Holdings or ABS-CBN, GMA, or Rappler. It's basically the same thing. So if, for example, pursuant to that clause in the RH Omidyar PDR, RH is not able to get the consent of RI for whatever reason, okay, all that this question provision does is to give Omidyar a ground to give up its investment. Okay? So it should be very clear. So negative covenants are very, it's very common. So although this one looks like to be a veto power, it is not a veto power in the traditional sense, in the legal sense, as we understand it in corporation law. Okay? But assuming, for the sake of argument, that this is indeed a veto power, there is a Supreme Court decision which basically says that veto power does not amount to ceding control. I think it's very clear, no? That principle, I think, which is based on some congressional deliberations, would give a very good defense, good legal ground for Rappler Holdings or Rappler Inc. to question the SEC decision. Because there is a difference between control and veto power. And that itself has been recognized by the Supreme Court as a protective mechanism for investors, which is what here it says, no? Assuming that it is a veto power that we understand under corporation code.
But Sir, SEC argued that it was already an admitted violation when Rappler submitted a waiver on that question provision.
No,
December.
I saw the submission, the waiver, and it was carefully worded. In other words, the Omidyar was saying, without admitting anything, just um, to lay aside the issue, we're willing to waive it, and we're waiving it.
That's what the waiver.
Yeah, it's there. I think I saw it, and it's very expressed without admitting liability. Yeah, it's not without. Yeah, it's not. No, I think since the SEC raised an issue of it over it, then the practical thing to do was to waive it para mawala na yung issue. Unfortunately, the SEC did not see it that way.
Did the SEC respond after Rappler submitted the waiver?
Walang as far as I know, I think the one who submitted the waiver was Omidyar because it came from Omidyar. I don't recall any response from the SEC. The next thing that happened was this decision.
The January 11 decision.
Yeah.
So, sir,
Ngayon, sinasabi ng SEC, by including that alleged veto power, a foreigner like Omidyar was given control over Rappler Inc. Okay? But there is also a Supreme Court decision that the term control refers to the election of the board of directors who, under the Corporation Code, controls and manages the corporation. So in that Supreme Court decision, I think it was Tebes versus Gamboa, the Supreme Court equated control with the power to elect the board of directors, which under the Corporation Code has the power to control and manage the corporation. In fact, the Supreme Court says, okay, a stockholder of a corporation exercises control over the corporation through the election of a director who is part of the board that controls the corporation. Okay? And the Supreme Court went on to say, one of the rights of a stockholder is the right to participate in the control or management of the corporation. This is exercised through his right to vote in the election of directors because it is the board of directors that controls or manages the corporation. So what does that mean? Insofar as the Supreme Court's control is exercised through the right to vote the members of the board of directors. A question, with this, even with this question provision, was Omidyar given the right to vote in the election of the directors of Rappler Holdings or Rappler Inc.? Definitely no.
Sir, do you think the decision of SEC to revoke Rappler's license and to declare null and void the Omidyar PDRs, are these too much?
In my opinion, with due respect to my friends in the SEC, it was too much, no?
Why so, sir?
Okay, it was too much because first, a careful reading of the question provision does not give control, as the term has been defined by the Supreme Court, to Omidyar. Okay? Number two, assuming that it gave control, of course, Omidyar and Rappler will not admit this because it's really clear. That provision has been waived. Number three, there are other stakeholders involved. For example, you have the employees, the stockholders, okay, the audience, the reading public, the one who the people access your website. They're being prejudiced. Okay, why do you punish these innocent people, assuming over something that they were not responsible for? Diba? For example, if the articles of incorporation is revoked, then you guys lose their job. The stockholders of Rappler Inc. and Rappler Holdings will lose their property ownership. They invested money, time, and efforts. building the two companies. By the way, all the directors, all the stockholders and directors and management of these two companies are Filipinos. There are no foreigners.
In your opinion, sir, what should have been SEC's course of action?
If I were the SEC, I would have approached this in a creative, pro-business, pro-investor manner, no? Anyway, na-waive na yung question provision. Okay? Or if I do not accept the waiver because it was belatedly made, I would have given the company a period to cure the defect. Okay? So, there were other measures that the SEC could have done rather than immediately revoke the Articles of Incorporation, which is killing the company immediately at the expense of innocent people.
Aside from the curing period, what could have been the other measures that they should have undertaken?
Or revoke that, declare null and void that particular provision. Diba?
Yeah.
Because anyway, the provisions are separable from each other. So everybody happy. Now, because what is prohibited by the Constitution is ownership and management of media by foreigners. There is that question. First of all, whether Rappler Inc. is media. Everybody can debate on that. Okay? But assuming that Rappler Inc. is media, what the Constitution prohibits is ownership and management. So the question is, did the Omidyar PDR give ownership over RH Holdings or Rappler Inc.? Question is no. Because the stockholders of the two companies remain the same. They were not diluted to give way to Omidyar. And the voting power remains in the stockholders of RH and RI. Walang voting power whatsoever ang Omidyar over the affairs of Rappler Holdings, much less of Rappler Inc. And as I said a while ago, the Supreme Court interpreted ownership of shares as ownership of voting stock. The question, did the Omidyar PDR give Omidyar the right to elect directors, even to vote on major corporate changes? No. Did the Omidyar PDR give in any way Omidyar the right to participate in the management of R Holdings, RH, Rappler Holdings, or Rappler Inc.? No, you know it because you report. Did you see any directors there? Did you see any management there, foreigners? No. So why do you revoke? Why do you go to that extreme penalty, kill the company, when there could have been other measures? Parang I liken it to a person. If you can cure a disease, cure it. Don't kill the person. Diba? Ganun lang yun from a layman's point of view. Give him a chance. Was there damage to the public? Wala. Was there a violation of the Constitution? Wala. Because the Omidyar PDRs did not give ownership and management to Omidyar. So, why immediately kill the company?
You said one of the measures that could have been undertaken is the curative period. Was there a precedent?
Yes. For example, there was this case, I think, Teves versus Gamboa, where the Supreme Court said that for purposes of determining whether a public utility like PLDT is 60% Filipino-owned is to determine whether or not Filipinos on 60% of voting stock. Okay? So anong ginawa ng SEC? Pina-implement ng Supreme Court sa SEC yung decision nila. So anong ginawa ng SEC? The SEC came out with Memorandum Circular number 8, I think, series of 2013, where it said, any nationalized company like PLDT who are not compliant with the decision of the Supreme Court, you have 1 year to cure the defect from the effectivity of the circular. Ang tanong ko, my question, why did the SEC not do the same? Why did the SEC say, okay, you are in technical violation, you are in violation, but we're giving you 1 year or even 6 months from receipt of this decision to cure the defect, assuming that they had reasons not to accept the waiver.
But sir, SEC's Attorney Pan argued that the curing period for PLDT was offshot of Supreme Court decision in the case of Gamboa. He cited Section 4 in the Memorandum Circular you've mentioned. It says that all covered corporations not compliant with constitutional ownership requirement shall be given 1 year from effectivity of the circular, which was implemented in 2013.
Okay.
So it's not a basis for Rappler.
If the SEC, there was nothing in the Teves decision which says that the SEC should give curative period. But the SEC did it on its own, and we agreed to that. The business sector was very happy that the SEC took a pro-business, pro-investor stance by issuing that circular. Ang question ko, why did the SEC not do the same? For the sake of the stockholders of the two corporations, for the sake of the employees, for the sake of the viewing public or listening public, for the sake of the families of those people who are directly affected by the revocation. Parang sa akin, I was going over the mission vision of SEC. Parang sinasabi, you should be the champion of investor protection. You should be judicious. You should be creative. We should be we should be the champion. This is the mission vision. We should be the champion for investor protection. We should be judicious. We should be creative. And if I were at the SEC, I would have done it that way. Okay? And everybody would have been happy. Now, I'm sure that although President Duterte had some harsh words on Rappler, President Duterte is pro-business. In fact, he has been traveling abroad, trying to get investors into the country. He's doing a lot of structural changes to help improve the business image, the business environment. Diba? Now here comes this decision where ninalify. Kaya that's part of the severity of the decision. Nilalify yung investment ng foreign investor. And we know that we're always going out. We're trying to improve them to get investors. What is the message that is being sent? Bakit hindi lang ninalify yung clause na yon? Bakit hindi inaccept yung waiver? When the thrust of the country is to get as many investors as possible, we're lagging behind in getting foreign investors in the country. And I just hope, for the sake of the country, that this will not send a very wrong message to the international community. I'm keeping my fingers crossed.
Sir, would Rappler avail of lawful remedies, including curing the violation found in SEC rules and SRC rules?
Ano, I think the legal remedy available now to Rappler Holdings, Rappler Inc. and Omidyar would be to go up to the courts of law to question that decision. Kasi I think Omidyar already has taken the right steps by waiving without that provision, which unfortunately was not accepted by the SEC. Actually, may kaso where the SEC revoked the articles of incorporation of a company because one of the incorporators was dead and there was some misrepresentation. Yung company involved na yan went up to the Court of Appeals. Okay? And the Court of Appeals issued an injunction against the SEC from implementing its decision. Now, fortunately, I think we do not have to get an injunction because the SEC has already, through Attorney Pan, and even I think through other commissioners, if I recall it correctly, have said that they will not implement the decision, di ba? Until their decision becomes final and executory, di ba?
Sir, earlier, Justice Secretary Aguirre already said that he will direct NBI to probe into Rappler and conduct case build-up. What would be Rappler's case of action?
Well, we will participate in the investigation and we will prove that there was nothing wrong about the question provision, that there's no violation of any law. And we just hope that everything will be done impartially.
Sir, lastly, what do you think would be the SEC's decisions impact on the confidence of investors in the Philippines?
That's what I was saying. I hope that this decision does not impact on the ability of our country to get more investments into the country, no? Because we are already lagging behind in terms of foreign direct investments. Okay, and I just hope that things like this should be decided judiciously because it may adversely affect our competitiveness. More so, it might adversely affect the perception of the international community on our country. No? I just want to be very clear. The SEC is trying its best. And we in the business community are very appreciative. They're trying to simplify the rules. They're trying to undertake measures that will make the ease of doing business better into the country. But I was hoping that things like this should not have happened. Because rightly or wrongly, decisions like this, which are perceived to be anti-investor, anti-business, in fact, if some say anti-freedom of the press, freedom of expression, okay? I just hope that it will not really change the competitiveness of the country kasi sayang naman yung efforts ng the whole government machinery, which includes the SEC. I think there are people there who are good, many of them. I just consider this siguro as one of the things that should have been avoided, that should have been decided very judiciously for the sake of the country.
Thank you, sir. We've been talking to Attorney Francis Lim, lawyer of Rappler, on the SEC decision to revoke its incorporation papers. I'm Chrissy De La Paz. Thank you for watching Rappler Talk.